Next case is Wendy A. Moore versus Dorothy M. Perry. Ms. Wheeler, do you wish to reserve any time?
Yes, Your Honor. 5 minutes, please.
You got it. You may begin.
Thank you, Your Honor. Good morning. May it please the Court, I'm Elizabeth Wheeler, and I'm here representing the appellant on this appeal. Ms. Moore was the defendant in the case below, and we're here because the trial court awarded an additor of a portion of past medical expenses which had not been awarded by the jury based on the conflicting evidence in the case. I'd like to just start off by referring to the statute which allowed the court to even consider the additor in the first place, and that's Section 768.043, subsection 2, which sets out the criteria for the trial court to consider when awarding additor. There are basically 5 things. One, the court is to consider whether the amount of the verdict indicates that it was influenced by passion, prejudice, or corruption on the part of the trier of fact. Number 2, whether the trier of fact ignored evidence or misconceived the merits of the case. Number 3, whether the trier of fact considered improper elements of damages or used speculation or conjecture. Number 4, whether the amount awarded bears a reasonable relation to the amount of damages proved and the injury suffered. And number 5, whether the amount awarded is supported by the evidence and could be adduced in a logical manner by reasonable persons. The reason why I wanted to just repeat those to the court this morning is that none of those reasons were stated in any order.
The order is just without any reasoning at all, isn't it? I mean, it's
correct. Well, Your Honor, there were actually 2 orders, if you remember the record. The first order stated that the additor was awarded because the court accepted plaintiff's attorney's argument that the award of a portion of the past medical bills coupled with an award of some futures was inconsistent. So the court gave a reason of inconsistency, which we felt was an issue that had been waived by any failure to object to the verdict at the time of trial. But then the court, without reason, entered the second order, entitled it amended order, and gave no reasons at all.
Well, but in the hearing itself, he did orally say that he thought the verdict was inadequate because all of the past medicals not associated with a heart condition should have been awarded, or something like that.
Well, actually what he said, Your Honor, was, and I went back and he said, there should have been no conflict over the remaining medicals, meaning the past medicals. And we cited a couple cases in our brief that on similar statements made by trial courts, the appellate courts found that kind of a reasoning was just not sufficient to support an additor. And I would go back again to the statutory factors. That's not one of them. There was nothing in the record, nothing in the order, nothing said by the judge to support the award of additor under any of these statutory factors. And in fact, the court made the statement that it was reasonable to conclude the jury could have reached the decision they reached. And I think that is basically following the last of the statutory factors, that is, whether the amount awarded is supported by the evidence and could be adduced in a logical manner by reasonable persons. To me, the court just almost paraphrased that particular criterion, and it does not support the award of an additor in this case.
Because there's conflicting medical testimony about whether the accident itself caused the injury?
Correct. There was conflicting evidence on both causation and the damages in this case. And basically, we go back to the case of Adams versus Wright, which was an early Supreme Court decision based on this particular statute, where the court said that, reiterated that a trial court cannot sit as a seventh juror, and before it sets aside a verdict or grants an additor, there has to be reasons in the record, it has to be supported in the record, or by findings that are reasonably amenable to judicial review. And we don't have either of those circumstances in this case. We don't have an order that sets forth sufficient findings, and we don't have evidence in the record. The two cases that I was referring to earlier were the Russell case out of the 3rd DCA in 2004 and the Ortlieb case out of the 4th DCA in 2004. In one of those, the trial court said or awarded additure because, quote, the damages awarded by the jury were clearly excessive. And in that case, the 3rd DCA said that reasoning was not sufficient to support the award of an additure. In the Ortlieb case, the trial court said that the jury inappropriately failed to consider unrebutted evidence as to medical expenses, and again, the court said that reasoning was insufficient. The Ortlieb case had facts almost identical to ours. Medical experts differed in their testimony as to the cause and the extent of the damages. The jury awarded $10,000 in past medical expenses, where the plaintiff was claiming about $21,000. And again, the 4th DCA reversed the additure in that case, saying again the trial judge couldn't sit as a 7th juror, and because the evidence was conflicting and the jury could have reached its verdict in a manner consistent with the evidence, it was error for the court to veto the verdict and grant the motion for additure. In our case, again, if you're looking at the record, a shortcut might be if you just simply look at the plaintiff's answer brief in this case. I think it points out some of the conflicting evidence that was in the record on these issues of causation and damages. The defendant's closing argument.
What was your contention as to why these were not appropriate bills to be compensated for through the damage award? I mean, did you contend that these bills were not incurred as a result of this accident, or I mean, what was your contention regarding the bills?
A couple of things, Your Honor. One is that the jury was instructed that they could, it was their duty to consider the credibility of the witnesses. They were told to award damages that they believed were reasonable and necessary as a result of the accident. They were told
I'm assuming the bills were put in evidence, weren't they?
The bills were put in evidence.
And they were put in evidence either by witness or by stipulation, I assume.
Yes.
All right. And then, there was some argument I would assume that was presented to the jury as to why they should or should not award damages based on these bills.
Yes, Your Honor.
And what was your contention as to why they should not award damages for these bills?
Well, that was one of the things I was going to point out was the defendant's closing argument, which starts at page 680 of the trial transcript, which I think sets out a lot of these conflicts and why certain medical bills were more appropriately attributed. This plaintiff had a number of pre-existing conditions. She was claiming injuries to her shoulder, neck, and back as a result of this accident, and she had pre-existing conditions in all of those areas. She had some electrical studies that were done that showed that she had polyneuropathy as well as carpal tunnel syndrome.
So your argument to the jury, and you're telling me that this was in closing argument, that all of these medical bills were as a result of injuries that she had sustained prior to this incident?
Not all of them, Your Honor, no. But there were,
some of them were.
In fact, what the defense attorney during closing argument said, well, maybe the treatment with the chiropractor was reasonable after the accident. But you get into all of these other things because if you remember, this was a case where this lady unfortunately had heart disease.
What evidence did you present to the jury that would indicate or show to the jury that all of these medical bills were related to injuries that were not caused by this incident?
Again, I don't know that there was any evidence that all of the bills were not related, but there was certainly a basis for the jury to conclude that some of the bills were not causally related to the accident.
What was the basis?
The pre-existing conditions that she had.
All right, but where was the testimony or where was the evidence to indicate that these bills and these expenses were incurred as a result of those pre-existing conditions rather than this incident aggravating them and then requiring the treatment?
One of the things that that I...
Put on any witnesses or evidence? I mean, you're telling me the bills were in evidence. Were they stipulated in evidence, or how did that happen?
I'm sorry, Your Honor, I can't answer that.
You don't know, but in any event, the bills were introduced into evidence and they were put before the jury.
Yes.
All right, and you didn't put on any evidence or any testimony to show that that the bills that were incurred were the result of treatment necessitated by a condition that was caused by some other incident and was not aggravated by this incident. And just tell me what that was.
Dr. Uricchio's testimony, for one thing, Your Honor, because he was the only doctor that had reviewed all of the plaintiff's medical bills. Medical records. He had records going back prior to the accident. He talked about the problems that were reflected in her prior medical records. This was an accident where
Did he go through the bills and say, well, the treatment reflected in this bill and the expense relates to to this injury or to this anomaly, and that wasn't caused by or aggravated by this, and then did he go through all the bills and do that?
I can't say that he went through each and every bill, but
did he go through any of the bills?
Pardon?
Did he go through any of the bills?
I don't recall that in his testimony.
So basically what you're telling me is that he testified that this lady or that this plaintiff had pre-existing conditions, and that's basically it. And then what you're telling me is you argued to the jury that, well, this bill was for this pre-existing condition.
No, Your Honor. I think that what I'm trying to say is Dr. Uricchio testified that this lady had a number of pre-existing conditions. Every single doctor agreed that she had degenerative changes in her neck, her low back, and her shoulder. Dr. Uricchio also talked about the fact she was overweight. She had been overweight, I guess, virtually all her life. He talked about the fact that overweight can cause back problems. She had a number of prior falls that caused her to, she had knee problems. She had actually gotten a handicap sticker for her car because of her knee condition.
Yeah, I know there was testimony that related to pre-existing conditions. I know all that. And the doctor put all that to the jury. But I'm trying to determine how it is that these particular bills and these particular medical treatments were attributed to that as opposed to the injury that was caused by this incident or aggravation of those pre-existing injuries that caused it.
What I think is that the jury accepted that this lady went to the chiropractor. The chiropractor testified that her symptoms improved with treatment. And he was the one who was Dr.
The jury accepted or made certain presumptions or assumptions. How did the jury, I'm trying to figure out how the bills were in evidence. There's no question that the bills were incurred. These were costs that needed to be paid, and apparently the jury had the bills. And I'm trying to figure out how the jury came to the conclusion that these were the result of treatment caused by injuries that were not related to this incident.
And, Your Honor, all I can tell you, I don't know how they came to their conclusion as to the amount, but all I can tell you is that I believe the evidence was susceptible of a finding by the jury that this lady, if she had an aggravation by the accident, it was a temporary aggravation.
If it is a standard for the court to apply that perhaps the jury made certain erroneous assumptions or guessed, and because of that, they didn't properly award these damages. You're saying that would not be a proper basis for evidence?
No, because I don't think. I think that because the evidence was conflicting, there was evidence from the chiropractor. She got better with treatment. Dr. Uricchio said she did not have a permanent injury. And so I think the jury could have reasonably concluded, based on the conflicting evidence, that maybe she had an aggravation that was temporary, that became better. I don't know why they awarded anything for the future, but it was certainly a lot less than what they were asking for. And I think maybe the jury gave her the benefit of the doubt and gave her a little bit more treatment for palliative care. I don't think that anyone can say how they reached at their conclusion, but you can unequivocally say that there was conflicting evidence in the record. There was evidence to support a finding by the jury that it was only a temporary aggravation. And so they awarded, and then she had this intervening problem with the heart condition that presented its own issues.
Well, but the plaintiff pretty much agreed that the heart condition, the medical bills associated with the heart condition was not.
They do now. They did not at trial. They were seeking to recover the expenses, not the expenses for the heart surgery, but she was in the hospital a couple of times for chest pain, and she was evaluated, and
the thing that's troubling me is that these bills were introduced into evidence. If they were not proper evidence, if these bills were not incurred as a result of injuries sustained in this incident or aggravation of pre-existing injuries, you would have argued that these bills should not come into evidence. These bills were not incurred as a result of this accident, rather than just have them come into evidence and then try and extrapolate to the jury that, well, perhaps this or perhaps that. I mean,
Your Honor, that was what the whole issue was. The issues to be tried were causation and damages, and so they were claiming they were related.
Okay, so are you telling me then that the bills were conditionally admitted into evidence?
No, and I don't know that it requires an unequivocal determination that bills are related. That's what the whole issue is. That's the issue to be submitted to the jury. The issue for your determination is whether you know the extent of the damages.
And that's why I asked you before, what is the evidence that we can look to say that, that these bills were not incurred as a result of this incident? And you're telling me, well, there was testimony that this lady had pre-existing injuries.
Correct.
And that's it.
She had pre-existing, she got better after treatment, and any additional bills were unrelated. So I will reserve the remainder of my time for rebuttal. Thank you.
Good morning. I'm David Ayers on behalf of Dorothy Perry. The evidence was that Mrs. Perry was rear-ended for no apparent reason, injured her neck, her back, and her shoulder. The medical bills that were put into evidence were some $43,000. $25,000 of that was for.
The opposing counsel doesn't know how the bills got into evidence. How did they get into evidence?
They were put into evidence.
A lot of times there's a stipulation, we'll just stipulate the bills come in, or you got to have somebody come in that testify that this was reasonably incurred as a result, and this wasn't.
I believe they were stipulated in.
Was it a conditional stipulation that, that we'll just submit the bills to the jury and then argue to them that, that they're not relevant to this incident because they weren't caused by this, or were they just stipulated that they come into evidence, period?
They were stipulated to come into evidence, period.
Wasn't it understood, though, that subject to materiality and causation and everything, I mean, that would go without saying in a stipulation of that kind, I think. I mean, certainly you understood it that way.
Well, they were arguing about everything in the case, but I mean, there was no agreements that they were conditional anyway. They went into evidence, and what we're asking for, what the judge granted, was the difference between the bills that were in evidence for her shoulder, back, and neck, and the amount that
the opposing counsel's argument is that even though there was no direct testimony from a witness that indicated that, well, this bill wasn't related to this particular incident or an aggravation of her pre-existing injuries. These bills were just related to injuries caused by, physical condition that existed before. What her argument is that, well, simply because there was evidence that this lady had pre-existing conditions, that was enough for the jury to base its decision that, well, we won't award these bills because we think they relate to the pre-existing condition.
They made a lot of arguments, and they suggested there was some accidents and falls, and my client admitted that, but there was nothing that came in that said she was injured in any of these accidents. Well, she did have a prior automobile accident, but she had no treatment. There was no injury. She did have a fall.
Well, Dr. Uricchio testified that he did not identify any significant orthopedic or other problem that resulted from the accident. Well, why is it that the jury couldn't believe that testimony and strip out those parts of the bills that they felt were inappropriate? What's wrong with them?
I mean,
don't juries do that all the time? They don't have to believe that your own client agreed that 2/3 of the bills were not at least now agrees, 2/3 of the bills had nothing to do with the accident. So why couldn't the jury believe that as well?
We had a little trouble seating this jury. My brief was, I think 17 or 18 of the jurors expressed some bias about caps and personal injury cases, and the trial court dismissed a number of, for cause of jurors that expressed some bias, and he was going to dismiss the whole panel, but we ended up going forward, so there was some problem there. And I think the court, under Florida Statute 768.043, has a duty to review what the jury did, and that's what he did in this situation.
No question. What part of 043 was it that he applied?
I believe he probably applied.
He probably applied?
He probably applied because in his ruling he said that, and so the court does find that there remains some $17,832.99 for which there should have been no conflict over, and that out of that, $10,582.99 was not awarded and should have been awarded for past medical expenses. And so he applied that, A, that there was an indication of prejudice, passion, or B, that it was clearly appears that...
He never said that.
Excuse me?
He never said that.
Yes, sir, he did not say that in his...
So you're speculating on what his reasons were.
I'm just reading what he said and reading the statute. But, you know, he was aware of, he was there for 5 days sitting through the trial and heard the evidence and heard, you know, what...
So are you saying he drew this conclusion because you had problems seating the jury in some of the questions that were elicited during voir dire examination?
I don't think that was the factor. It might have been a factor. I think the main one was that they ignored the evidence. Under B, they ignored the evidence and reached...
Well, what's wrong with evidence and testimony that clearly shows that the plaintiff has pre-existing injuries and conditions? Bills are introduced in evidence, and the jury, without more, just says that, well, we look at these bills, and you know, as finders of fact, we're saying that this bill relates to the prior injury and should not be compensated. What's wrong with that?
First of all, I don't think there was any evidence of any prior injury. There was evidence of accidents, but no evidence was introduced of any prior injury, first of all. Second of all...
condition, though, not injury, but condition. Prior condition, not injury.
Conditions are injuries.
She might have arthritis, but there's no evidence of any injury before. She was a school teacher for 30 years. She didn't have any problem doing any of that.
Well, Dr. Wright said there was a degeneration throughout her entire cervical and lumbar spine, and so did Dr. Giesel. I mean, there were two doctors that said she had extensive pre-injury, pre-accident arthritis.
Right. They said she had pre-accident arthritis, but they also said that she was injured as a result of this accident.
And she got compensated.
Well, she didn't get anything for her pain and suffering because they didn't find that. She didn't get anything for...
They found no permanency.
She had no permanency according to the jury, which we're not here fighting that. We're just saying that they did not, and the court agreed after reviewing everything, that they did not award for her past medical when there was no reason why they should not have. They awarded for future medical, but they didn't award for all this past medical.
Well, you can account for that by palliative care.
Excuse me?
I said you can account for the future medicals by palliative care award, I suppose.
Well, if it's not related to the accident, it's not reasonable.
Well, maybe we should strip that out too, then.
Well, yeah, a lot was already stripped out. We don't want to strip any more out. But, you know, the reason we put on the heart thing is because a doctor said that she was seen in the hospital for some $25,000 worth of bills that he felt were related to this accident. And we left it up to the jury. They said no, but we're not arguing that here today before this court. What we're arguing is the actual bills that are in evidence that she treated with her orthopedic doctors, neurologists, neurosurgeons that said that was related to the accident. It was not assigned by the jury. They did assign future damages for medical. They didn't assign all those. And the judge, in using his duty under the statute...
What testimony did you elicit that showed that these particular medical bills were caused by the injury caused by this accident?
We enlisted...
Other than just the stipulation that the bills are in evidence.
We enlisted it from the doctors that were called, Dr. Smith, Dr. Yandel, Dr. Gazard and Dr.
Okay, and are you saying that all of these doctors testified that all of this medical care and all of these bills, and I'm talking only about the bills that are subject to the editor, they were incurred as a result of the injury sustained in this accident?
Yes.
Did you have testimony that the heart condition, that the bills associated with a heart condition were also sustained in the accident?
Yes, we did.
And you find nothing wrong with the jury disagreeing with that part?
I can understand that, but I can't understand why they didn't award the bills that for her neck and back that were caused when she was hit in the rear and started treating from the day of the accident up until the time of the trial. And the trial judge that heard everything and complied with the statute, apparently saw likewise. He denied our motion for editor loss of wages for these medical bills from heart condition for a new trial and everything else, but he did feel that the medical bill, these $10,000 for the medical bills, should have been awarded, and they were not. They could have asked for a new trial. They chose not to do so. So the only thing we're here about today is this additional $10,000 that the judge awarded under the statute. Is that reasonable? And I think the bills were in evidence. They were related to the accident by the doctors and by my client. She didn't have any injury before. She did have arthritis, but she didn't have any injury. And that pursuant to the statute, that the judge was correct and comes with presumption of being correct, and that should be affirmed.
Thank you. Thank you, counsel.
Just a couple of things. One is that every single doctor that related his treatment or problems to the accident did so based solely on the plaintiff's history to him that she didn't have any problems.
Yeah, but you agreed with opposing counsel that, these doctors testified that, they rendered this care and treatment based on what they felt were injuries that this person sustained as a result of the accident, and that's what these bills were all about.
Your Honor, the reason why they related was based on the plaintiff's history. They did not do it on the basis of any kind of objective medical findings.
That's my question was, not the basis for the doctor's testimony, but did the doctors testify that I rendered this care and treatment and charged this person, these bills based on the care and treatment I rendered for the injuries sustained? That's opposing counsel just told us that. Is that?
Your Honor, I don't think there was actual testimony from the doctors about their bills. I think that the doctors testified about the condition and about causation. But did they testify about the care and treatment they rendered for her? They probably did, but I don't think they were shown their bills and said and asked, is this bill related to the accident? I do not remember that from the record. I think that the only reason they related, I know that the only reason they related any problem, any complaints to the accident was because they
are these contested bills that these doctors for treatment that these doctors rendered and that they testified to as a result of this accident or not?
I do not believe that the doctors actually testified this bill was related as a result of this accident.
You're saying they didn't take this bill and go through all the bills, but they testified as to the care and treatment. You just told me that. And didn't they? They told the jury what care and treatment they rendered to this person?
Yes.
All right. And are there any of these bills that do not particularly or specifically relate to that particular care and treatment?
No, but the doctors related their care and treatment to the accident only because the plaintiff told them that that she didn't have problems before, and the jury, that was a credibility issue for the jury. That goes back to Eastgold versus Rhodes and other Supreme Court cases saying that the jury doesn't have to accept expert testimony, especially when it's based on a report of history by a claimant, by a plaintiff. And that then raises the whole issue of credibility, which is absolutely the province of the jury.
I'm just trying to figure out how they parse the bills. We'll pay this one, we'll give them this one, this one, this one. We won't give this one and this one and this one when there was doesn't seem to me any evidence or testimony that would allow them to do that with any degree of accuracy or certainty. But maybe that's not the standard that they have to apply. They just have to say, we're going to award this and we're going to award that. But I'm having a hard time finding the basis for it. I mean, especially when they paid some of them. As
I said, Your Honor, I think that the basis for it was Dr. Uricchio's testimony, the fact that the jury found the plaintiff to not be credible. They didn't award the heart condition, the two hospitalizations for just the test, because the doctor related that based on a report to him by the plaintiff that she had had chest pain since the accident, and the jury obviously didn't believe that because they didn't award the heart conditions. That was the only reason that was related. Mr. Ayers talked about problem seating the jury, but that was asserted as grounds for his motion for new trial, which was denied by the trial judge, and he didn't raise any issue on this appeal about that. So I don't think that...
That's not an issue on appeal.
It is not an issue on appeal, and I don't think that, for that reason, I don't think that you can say that the additor was awarded because of some prejudice or passion on the part of the jury. There was no such finding by the trial court, and I think he implicitly rejected that. Before I leave, I just wanted to remind the court that we did also raise an issue as to the set-off for the short-term disability payments against the lost wage award.
That we'll deal with it, but your time has expired.
All right. Thank you, Judge.
Thank you.